Welcome, precious viewers, to my YouTube channel, Gwungmijana's Legal Discourse. Today's video is for my Equity and Trust 2 series, which is the law of trusts. As you ought to know, equity is divided into two. Equity and trust. One deals with the general principle of equity first semester, and then equity and trust 2 deals with the law of trust. So today we are dealing with the law of trust. And our topic, the topic for today is the meaning and nature of trusts. Meaning and nature of trusts. It is important to know that when you are talking about the nature of something, it also includes the meaning. So the meaning of any particular thing is part of the nature of that thing. So you cannot talk about the nature of a thing without mentioning its meaning. So in case you are faced with the question, discuss the nature of trusts, you are going to talk about, it requires you to also talk about the meaning. But the meaning of a thing may not, the nature of a thing may not be embedded in the meaning of that thing. That is, all the characteristics, because nature has to do with characteristic, the inherent quality of a thing. So all the characteristics of a thing may not be embedded in the meaning. However, the meaning is part of it. So what is trust? Well, there's no straightforward answer to the question, what is trust? As you ought to know also by now that almost every legal concept have the problem of definability, the problem of undefinableness. That is the problem of definition. So generally, there's usually a problem of defining legal concepts. So trust is not an exception. In fact, it may interest you to know that many scholars and writers have propounded, have given several definitions, but no one is precise and exact. So that's the situation. So in defining trust, the first important thing to mention is that there is a problem of definition. And accordingly, many writers and authors have propounded or given several definitions, but none is precise enough and comprehensive enough or satisfactory. None of the definition had been satisfactory. So that is the first point, that there is a problem of definition. Now, however, it is important to note that the most comprehensive definition, the most common definition, the most adopted definition is the one given by Professor Keating. Professor Keating, in his book, in his book, Law of Trusts, 8th edition, I think I'm correct. Let me confirm that. Law of Trust, yes, Law of Trust, 8th edition. So Professor Keating definition is the most comprehensive and the most generally acceptable definition. In fact, even the judiciary, that's the definition they always adopt. So even if you are looking for a judicial definition, you may end up seeing Professor Keating's definition. That's the one always adopted by that is often adopted by the judiciary. How does Keating define trusts? As I mentioned earlier, that several scholars, so will not only look at only Keating's definition, we shall look at the definition by other scholars, a few other scholars, before we look at that of Keating. However, before doing that, let's actually try to understand what it is in a simple term, in a colloquial term. Let's look it in a light manner to know what trust is. By the time it will be explained in a simple term, then while looking at the scholarly definition, it will be better appreciated and well understood when we try to explain what trust is in a simple term. Then you can better appreciate the scholarly definition and it will be well understood. So in a simple term, what is trust? Trust is just where a person who owns a property or has an interest in property wants that property to be for the benefit of another person. The person wants the benefit of that property. He wants another person to enjoy the benefit of that property. However, instead of giving that property to that person who he wants to the person that he wants to enjoy the benefit of the property, he gives it to another person to hold for the benefit of that other person. At this point, permit me to introduce my names for illustration. There are some names I've chosen for my examples, for my illustration. I have a guard, I have lad, I have sad, I have long, and I have young. Those are the names I will always use for illustration in course of my tutorial. So let's use them as example. So for instance, God has a property, maybe a land, but the benefit coming from that land, the benefit of that land, God wants young to be the one enjoying the benefit of that land. Maybe if it is rents that is accruing from the land, God, the owner of the property, wants it to be used for the benefit of young, or maybe for the education of young. But instead of giving the property directly to young to old and also enjoy the benefits, God decided to transfer the property to long. So God transfers the property to long, to not for the benefit of long, but for long to hold it on trusts for the benefit of young. That is trusts. That is simply trusts. One's property has been transferred to another person to hold on trust, to manage, to keep, for not for his benefit, for the benefit of another. That's simply trusts. So that's what trust means, where God who wants Young to benefit from his property, instead of giving it to Young directly, transfer the property to Long, for Long to maintain, for Long to control, for Long to keep it for the benefit of God. And the reason for that might be best known by God. It could be that, okay, young, as the name implies, is too young to hold a property, to own a property at that age. So he will now transfer it to another person to hold for him. Or it could be that Young is an extravagant person, cannot be trusted with a property. Maybe if the property is given to him, let's assume that he's not a young person. If the property is given to him, he will not manage it properly. He will squander the whole proceed, which is for his education. Then God now decided to give the property to another person to hold on trust for him. Or it could be that under a trust, the stator, the way he wants a particular property to be managed. So under his will, he may decide to create a trust of that property based on the way he wants it to be managed. Maybe he wants the property to be held on trust for the benefit of orphans. So it depends on the uses to which the owner of the property want to make use of the concept of trusts. Could be to provide for other persons, or to fulfill a particular aim in his mind. So that is generally the concept of trust. So as we shall see this scholarly definition, you will see that it will all end with all what the definition will be saying will all be about, despite how long or how short it might be. It will all be about a person being under the obligation by law to hold property for the benefit of another person. That's what we shall discover as we shall look at the various definitions. So I hope that is clear, that once property is given by the owner to another person to hold on trusts, to manage, to keep, to maintain for the benefit of another person, that is simply trust. That's what trust is all about. There's no two ways about it. So that is trust. Now let's now look at it appropriately by considering some scholarly definition. But before I do that, in trust concept, in trust there are three parties. The settlor, that's the original owner of the property. That is, in our example, God is the settlor. Then we have another party, the trustee or trustees. So in our example, Long is the trustee. It could be more than one person. That's trustees. Also known as this particular word, there's usually several pronunciations, but according to the Black's Law Dictionary transcription, you can pronounce it as setiki trusts, or sestwiki trusts. So the beneficiary is also known as the setiki trust or the sestwiki trusts. That's another name for the beneficiary. So there's another party in a trust relationship. Then another party is the beneficiary. Okay, I just mentioned this to law, the original one, and then the beneficiary, also known as the Sestiki trust. Then we have the trustee. The trustee is the person that the property is transferred to hold on trusts for the beneficiary. So the beneficiary could be one person or more than one. There's beneficiaries. Also, the trustee could be one person or more than one person. There's trustees. So those are the parties in a trust relationship. So at this point, let's now look at the various definitions of trust as given by scholars. We shall look at the definition given by Underhill, Henry or Honor, and the definition by Petite and that of Keating. So permit me to look for the definition here. Okay, so Underhill define trust. Thus, according to Underhill, a trust is defined as an equitable obligation binding a person who is called a trustee to deal with property over which he has control, which is called the trust property, for the benefit of persons who are called the beneficiaries or statutory trusts, of whom he may himself be one, and any one of whom may enforce the obligation. That's the definition by Underhill. Let's look at the definition by Honor, or if you may wish to call it Henry. Define trust as a trust exists when property is to be held or administered by one person on behalf of another or for some purpose other than its own benefit. That's the definition by Honor or Henry. Then, according to Petite, a trust is an equitable obligation binding a person who is called a trustee to deal with the property over which he has control, which is called the trust property, whether for the benefit of persons whom are called the beneficiaries or statutory trusts, of whom he may himself be one, and any of whom may enforce the obligation for a charitable purpose, which may be enforced at the instance of the Attorney General or for some other purposes permitted by law, though enforceable. So that's the definition by Petite. Then let's now look at the most comprehensive definition by Keating. The most comprehensive and the most common definition by Keating. It defines trust as follows. A trust is a relationship which arises wherever a person called a trustee is compelled in equity to hold property, whether real or personal, and whether by legal or equitable title, for the benefit of some persons of whom it may be one and who are termed statutory trusts, or for some object permitted by law in such a way that the real benefit of the property accrues not to the trustee but to the beneficiaries or other objects of the trusts. So those are the definition propounded by some scholars, and that of the most comprehensive definition by Keating, which as I've mentioned earlier, is usually adopted by the judiciary in our courts. Now, as I've said, one thing continue to run through all those definitions, and the point is that it's just where property is given to somebody known as a trustee, or it could be more than one trustees, to manage it, to keep it, to maintain it, to control it, or to hold it. for the benefits of another person known as the beneficiary, as the name implies, it benefits. So there is just a word trust. It's all about. Once that is done, once a person has given property to another person to hold on trust for another, then the trust has been created. So there's what trust is about. But let's look at some key things that can be noted from the above definition or the definition that has been given. Essentially, the definition of key thing. What are those things that can be that is worthy of note? What is designable? What can be taken note of from the various definition is that the trustee may also be a beneficiary. So the trustee, from the definition we have seen, can also be one of the beneficiaries. So the person who is holding the property, keeping the property, can also be one of the person to benefit from. Then another thing also to be taken note from the definition is that trust may be created to for other objects, for other objects other than human. So the objects of the trusts could be any other thing apart from human. So it's not only human that the trust can be created for. It is not only for the benefit of humans that trust can be created. So trust can be created for the benefits of any other thing that is not a human being. That's one thing worthy of note from the definition. Also, another thing we should take note of is that generally the trustee is the legal owner of the property. So in trust, the trustee is the legal owner of the property, while the beneficiary is the equitable owner. So from this, you can see that a trust allows for the division of ownership between several persons. So in a trust concept, several persons can own a particular property simultaneously, concurrently, at the same time. Trust allows several persons to have interests in a particular property at the same time, simultaneously, concurrently. So that's one of the beauty of trusts. No wonder Maitland observed that trust is one of the greatest achievements of the English courts. That one of the greatest achievements of the English courts is trusts. So it's a very it's a good development and innovation that is very fundamental. So that's another important thing to note. Then the nature of trust. As I've said, by looking at the meaning, we are still talking about the nature of trust. But one fundamental and important, or the main nature of trust, as we have even seen from the meaning, is that when you are writing about the nature of trust, you must mention it, that the main or the fundamental nature of trust is that the property is vested in the trustee, not for its own benefit. So the important nature of trust is that the property is vested, is transferred to the trustee, not for its own benefit, but for the benefit of the beneficiary, for the benefit of the beneficiary, and not for the benefit of the trustee or trustees. That's one fundamental nature of trusts. Furthermore, let's also look briefly at the requirement for the validity of trust. So for a trust to be valid, it must involve specific property. Subsequently, we shall still look at it, a requirement for the validity of trust. But generally, for a trust to be valid, for you to say this trust is validly created or is a valid trust, it must involve specific property, it must reflect the settlor's intention, and it must be created for lawful purpose. So that's the general requirements for the validity of trust. So take note of that. So that's what trust generally entails. So I hope it is understood. Then in subsequent video we shall continue with the lecture by looking at the classification of trusts. So in the subsequent video we shall continue with the classification of trust. In that video you will know how trust is classified. Please do not forget to subscribe to the channel and then press the notification button so that you can always get the video. Also beside that, that's what keep this particular endeavor moving. Thank you and see you in the next video.